Hi, this is Usha. Welcome to Rathod's IAS classes. Today in this lecture, we are going to see the next chapter of Lakshmikant, that is basic structure of the constitution. Before going into the topic, many students have the doubts regarding this basic structure of the constitution. They do not know even what are the series of the steps that happened that led to the evolution of the basic structure doctrine. So I want to make you a promise that after listening to this lecture, you will not have any doubt regarding this basic structure doctrine. So I will try my level best to make you to understand this topic, that is evolution of the basic structure doctrine. So in this lecture, we are going to see about three important cases. The first one is Shankari Prasad case. Shankari Prasad versus Union of India 1951. And the second important case is Golaknath case. Golaknath versus State of Punjab. And the third important one is Keshwanand Bharati case. Of 1973. So these three are the important cases that you should remember whenever you are reading about this basic structure doctrine. So let's get started with our lecture. First, let us see how this basic structure doctrine evolved. So the first important case that you should remember is the Shankari Prasad versus Union of India 1951. So what is the story? Why this Shankari Prasad, who went to the Supreme Court, why he challenged the petition? So if you see in 1951, we saw mainly the Jamindari system. Jamindari system is present and there is a need of the land acquisition. So the first Prime Minister at that time was the Prime Minister Jawaharlal Nehru, that is Pandit Jawaharlal Nehru. Pandit Jawaharlal Nehru want to acquire the land. Mainly he want to divert those land for the developmental purpose, like the building of the industries, factories or other developmental activities. But at that time there was a Jamindar system was present. So we saw there are the landlords are present. The most of the land which is present in the hands of these Jamindars. So Jamindars were not ready to give the land. So at that time, according to the Article 31, which talks about the right to property. Right to property, it is a fundamental right at that time, and these Jamindars are not likely, they are not want to return the land to the government. So what happened? The government came up with the articles, that is Article 31A, Article 31B, mainly through the Constitution Amendment Acts, and they are added to the Constitution. The main objectives of the Article 31A and Article 31B of the Indian Constitution, it is to make the effective land reforms in the country. But if you see, whenever these articles which are introduced or amended by the Constitution and added to the Article 31, then that led to snatching of the fundamental rights of Article 14, Article 19 and Article 31 of the Indian Constitution. So, this Shankari Prasad, who went to the Supreme Court and challenged his, because it is violating the Article 14, Article 19 and Article 31 of the Indian Constitution. The petitioner asked the Supreme Court mainly that how can the Parliament enact any legislature or any law which snatches the fundamental rights or abridges the fundamental rights. So here he is challenged that how the Parliament can take away the fundamental rights or abridge the fundamental rights. Then the petitioner asked the Supreme Court to look at the Article 13 subclass 2. If you see the Article 13 subclass 2, it mainly talks about the Parliament do not have the power to abridge the fundamental rights. So there is no power to the Parliament mainly to abridge the fundamental rights according to the Article 13 subclass 2 of the Indian Constitution. Then again Supreme Court retaliated and Supreme Court responded and said to look at Article 13 subclass 3. So if you see the Article 13 subclass 3, it talks about the definition of law. So under this definition of law, it includes acts of the Parliament. It also includes the rules, regulations and also notifications. by law, and according to this Article 13 subclass 3, it does not include the Constitutional Amendment Act. So because of this, Article 13 subclass 3 does not contain the Constitutional Amendment Acts. These are not included under the definition of the law. So under Article subclass 3, the definition includes acts of the Parliament, rules, regulations, notifications which are made by the law, but it does not contain the Constitutional Amendment Act. So Article 31A and Article 31B are constitutional. So the Parliament has the power to amend the fundamental rights, and it is by the Constitutional Amendment Act, because this Constitutional Amendment Act does not come under the definition of law. So later on, the judgment of the Shankari Prasad was again challenged under this Golaknath versus State of Punjab of 1967. So under this Golaknath versus State of Punjab, again the judgment of this Shankari Prasad was challenged. So what happened here? The judgment which is given under this Shankari Prasad was overruled by the 11th judge bench here, and the judgment which is 6:5 majority, they said that the word law, which includes the Constitutional Amendment Act, also under the Article subclass 13 subclass 3. So again the judgment which is given under this Shankari Prasad, that is overruled in this Golaknath judgment, and said that the word law, which includes the Constitution Amendment Act, also according to the Article 13 subclass 3. And it also said that Article 368 does not contain the power to amend the Constitution by the Parliament, but merely it provides a procedure to amend the Constitution. So this is the important thing that was talked in this Golaknath versus State of Punjab of 1967. And it also said that Parliament do not have the power to amend the fundamental rights. So this is the important judgment which is given under this Golaknath versus State of Punjab 1967. So later on, what happened? The Parliament came up with an amendment and added 24th Constitutional Amendment Act of 1971. Through this 24th Constitutional Amendment Act 1971, it changed the two articles. The first one is Article 13 and the second one is Article 368. So the changes made under these changes, Article 13 subclass 4 added, and under Article 368 subclass 3 added. So let us see what is this Article 13 subclass 4 and Article 368 subclass 3. So if you see this Article 13 subclass 4, it says nothing in this article shall apply to an amendment of the Constitution which is made under Article 368. And if you see Article 368 subclass 3 says that it provides that nothing in the Article 13 shall apply to the amendment under this article. So what is the meaning of the Article 13(4) and Article 368 subclass 3? In a simple words, Parliament have the power to amend the Constitution and also amend the fundamental rights, but only it can be done through the amendment which is done under the Article 368 of the Indian Constitution. So this is about Article 13 subclass 4 and Article 368 subclass 3. So this amendment also changes the text of the Article 368. So if you say the Golaknath judgment, it said Article 368 have only mere procedure but not talking about the power of the Parliament. So through the 24th Constitutional Amendment Act, again the Parliament also changes the text of Article 368 by substituting the procedure for the amendment of the Constitution with the power of the Parliament to amend the Constitution and the procedure thereof. So in this way, it also changed the text of the Article 368. So this is very, very important. So later on, there is a famous case, that is a Keshwanand Bharati case, that is Keshwanand Bharati versus Union of India 1973. The date of the judgment, it is very, very important, that is 24th April 1973. So what happened? What is a petition here? The petition, it is challenged the Kerala Land Reforms Act. So at that time, the Kerala government also came up with the Land Reforms Act, and it is acquiring private property mainly for the development process, mainly to abolish the Jamindar system in the Kerala. So at that time, this Keshwanand Bharati, who was an young man, he was the leader of the some religious math in the Kerala. So his land also acquired by the government. Then what happened? The fundamental right of Article 26, which talks about the managing of the religious institutions, it is violated by taking away the land that belongs to this math. Later on, the petition was challenged this Kerala Land Reforms Act, and there are also several other constitutional amendment acts that were challenged during this time in the Supreme Court. They include 24th Constitutional Amendment Act, 25th Constitutional Amendment Act, 29th Constitutional Amendment Act, and these all are clubbed together, and the judgment which is given under this Keshwananda Bharati versus Union of India 1973. Mainly the questions asked in this case were, is the Parliament have the power to amend the Constitution? And it also asked, is the 24th Constitutional Amendment Act valid? Then Supreme Court said Parliament have the power to amend the Constitution and also the power to amend the fundamental rights, but Parliament do not have the power to amend the basic structure of the Constitution. So if you see this Keshwananda Bharati judgment, it is given by the 13th judge bench, and the judgment it is 7:6. So in this judgment, it evolved the structure called as basic structure doctrine. So if this basic structure it is amended, the whole identity of the Constitution will be lost. So this will not be allowed by the Supreme Court. So it said that Parliament has the power to amend the Constitution. It also has the power to amend the fundamental rights, but the Parliament do not have the power to amend the basic structure of the Constitution. So in this way, there was the evolution of the basic structure doctrine happened. So later on in 1971, there were the elections, and in those elections, Indira Gandhi government came into power. After Indira Gandhi came into power, from 1975 to 77, the internal emergency which is imposed by the Indira Gandhi government, and during this period, she came up with a significant amendment to the Constitution. So one of the most important amendment is 39th Constitutional Amendment Act. So that is 39th Constitutional Amendment Act, which talks about the election of the President, Vice President, Speaker, Prime Minister. They are not challengeable in the court of the law. So again the matter went to Supreme Court. Supreme Court said it is against the free and fair elections. So if you see this free and the fair elections, it is a part of the basic structure of the Constitution. So it is not allowed. So it struck down the 39th Constitutional Amendment Act. Okay. So if you see, if there is no basic structure doctrine which is evolved by this Keshwananda Bharati case, there would be the corrupt prime ministers, corrupt presidents, corrupt vice president, etc. So in this way, Keshwananda Bharati case which saved the Indian democracy. So you can write this example whenever there is a question which appear under the GS paper 2 regarding this polity, regarding this basic structure doctrine. I hope this is clear now. So let us see the next part of this lecture. We are going to see about the elements of the basic structure. So if you see the present position of this basic structure, the Parliament under Article 368, it can amend any part of the Constitution, including the fundamental rights, without affecting the basic structure of the Constitution. So now at present the Parliament have the power to amend the Constitution, amend any provisions what it want, but not the basic structure of the Constitution. So if you see the Supreme Court, it to define or clarify as to what constitute the basic structures of the Constitution from the various judgment. So the Supreme Court only said that the basic structure cannot be amended, but it does not tell about what are the important things which comes under the basic structure. So these will be told by the government or by the Supreme Court by the case to by case judgment. So if you see the following are emerged as the basic features of the Constitution or the elements of the basic structure of the Constitution. So if you see, they include the supremacy of the Constitution, sovereign, democratic and republic nature of the Indian polity, secular character of the Constitution, separation of the powers between the legislature, executive and judiciary, federal character of the Constitution, unity and integrity of nation, welfare state, judicial review, freedom and dignity of the individual, parliamentary system, rule of law, harmony between the fundamental rights and the DPSP, principle of equality, free and fair elections, independence of judiciary, limited power of the parliament to amend the constitution, effective access to the justice, principle underlying the fundamental rights, power of the Supreme Court under Article 32, under Article 136, 141 and 142, and the power of the High Courts under Article 226 and Article 227. So these are some of the important comes under the basic structure of the constitution. So in the Lakshmikant, in the last pages, you see in which case which has evolved. So you can read that. Okay, so by this we are concluding today. I hope you understand this lecture. Thank you so much and please subscribe to my channel. Thank you.